Senate will come to order. The senators will please take their seats. The senators and all in attendance will please stand and be led in prayer by the Honorable Lionel Spruill, Sr., Senator from Northern Chesapeake. Following the prayer, everyone will please remain standing and be led in the Pledge of Allegiance to the flag of the United States of America by Portia Brown, Administrative Assistant, Senate Clerk's Office.
Thank you. Let us pray. Bless the Lord, O my soul, and all that is within me, bless his holy name. Bless the Lord, O my soul, and forget not all his benefits, who forgive all our iniquities, who heals all our disease, who redeems your life from destruction, who crowns you with love, kindness, and tender mercy, who satisfies your mouth with good things. God, my Father, once again, we come to you to thank you because you have been so good. Thank you, dear Father, because you allow us to wake up this morning to see another day. Ask you, dear Father, to please, as you said in 2 Chronicles, if we will turn from our wicked ways, you will heal the land. Dear Father, let me start by saying, bless this world, dear Father. You know what we are all about, this disease that we have. Touch, dear Father, in the name of Jesus, that you will heal the land. Dear Father, bless those who are in Washington, from the president on down. Touch their heart. Let them know, dear Father, that Jesus awakened me, that they would do the business of the people. Dear Father, come on down to Richmond. Bless each and one of us, starting from the lieutenant governor, all the members, the clerks, his staff, state troopers, and all who are here, dear Father. Touch our hearts that we may do what's right. Dear Father, please forgive us because we have sinned. Touch all of our citizens, dear Father. Please have some control of what's going on in the streets. Let us know, dear Father, we will only pray and turn to you. You will forgive our sins. We'll be all right. Dear Father, let us now do what business you asked us to do in this place, that we will be so careful to give you all the honor, all the glory, and all the praise. In Jesus' name we ask these things. Amen.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
$10,000.
Great job. Clerk will call the roll. All those in attendance will please record their vote aye. Clerk will close the roll.
You have a quorum, Mr. President. Senate Journal for Monday, August the 24th, 2020.
The senator from Bath, Senator Deeds, moves that the reading of the journal be waived. All in favor of waiving the reading of the journal will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 29, noes 5, Rule 36-1.
Ayes 29, noes 5, Rule 36-1. The reading of the journal is waived. The clerk will report any communication from the House of Delegates.
We do not have any, sir.
Thank you, Madam Clerk. The clerk will report any communication from the governor.
We do not have any, sir.
Thank you, Madam Clerk. Bills, petitions, and resolutions are now in order. Is there any other business to come before the Senate in the morning hour?
Mr. President.
Senator from Franklin County, Senator Stanley.
Thank you, Mr. President. Would the journal please reflect that my socially distanced seatmates, Senator Fogel and Senator Reeves, are each away on pressing personal business?
Thank the Senator. The journal will so reflect.
Mr. President.
Senator from Hanover, Senator McDougal, sorry.
Mr. President, would the journal please reflect that the senator from Harrisonburg is away on pressing personal business?
Thank the Senator. Journal will so reflect. Do any other senators wish to be recognized? The junior senator from Richmond City, Senator Morrissey.
Thank you, Mr. President. Mr. President, if it's appropriate, may I rise for a purpose of an announcement?
Senator, has the floor.
Thank you, Mr. President. Mr. President, I spoke with our friend and colleague, Senator Reeves, last night about 10 p.m. Really strong voice, doing really well. He told me that he has very, very, very minor symptoms and looks forward to being back with all of his colleagues as soon as possible. He also wanted me to remind Senators Norman, Obenshain, Stanley, and McDougal to please come to his house tonight, leave your masks behind, have an intimate dinner and a rousing game of Twister afterwards, and a little brother bonding. Thank you, Mr. President.
Thank the Senator. Senator from James City County, Senator Norman. Senator from Hanover, Senator McDougal.
Mr. President, I was going to ask the gentleman from the city if he's going to be willing to cover our medical bills after we take him up on his offer, and maybe a little bit of litigation expense.
Mr. President.
Virginia Beach, Senator DeStep.
Mr. President, I'd like the Journal to reflect that the good senator from Lynchburg is away on pressing personal. Oh, as you were, Mr. President, carry on.
Thank the Senator. Senior Senator from Fairfax, Senator Saslaw.
Mr. President, I would ask that we stand in recess till, make it 1:45.
Without objection, Senate will stand in recess. Senator from Hampton, Senator Locke.
Thank you, Mr. President. Upon recess, I ask that the Democratic Caucus meet in our usual place.
Thank the Senator. Senator from James City County, Senator Norman.
Thank you, Mr. President. I'd respectfully invite the reduced members of the Republican caucus to go to our prayer meeting area.
Thank the Senator. Without objection, the Senate will stand in recess until 12:45 p.m. Senate will come to order. The senators will please take their seats. Clerk will call the calendar.
Senate calendar for Wednesday, August the 26th, 2020. Uncontested calendar, Senate bill on third reading. Senate Bill 5036, a bill relating to alcoholic beverage control, local special events license, limitations on events during public health emergency.
Senator from Prince William County, Senator McPike.
Thank you, Mr. President. I move that Senate Bill 5036 pass. Speaking to the motion.
Senator has the floor.
Thank you, Mr. President. This bill provides and affords localities an ability to extend their ABC permit license to multiple restaurants where they have common areas, whether it be small parks or pavilions, to help their local restaurants in times where the public health emergency exists and restaurant capacity has been reduced. So this is a narrowly defined bill that would lift the number of days that the special event permit license would be in effect, and move that the bill pass, Mr. President.
Thank the senator. Do any other senators wish to be heard? Seeing none, the question is, shall Senate Bill 5036 pass? All in favor of passing the bill will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk, close the roll.
Ayes 36, no 0.
Ayes 36, no 0. Senate Bill 5036 passes.
Regular calendar, Senate bill on third reading. Senate Bill 5032, a bill relating to assault and battery against a law enforcement officer penalty.
Senator from Eastern Fairfax, Senator Serville.
Thank you, Mr. President. I move the bill pass and speaking to that motion.
Senator has the floor.
Thank you, Mr. President. Ladies and gentlemen, this bill in front of you, you probably heard a little bit about. I'm going to, first of all, want to talk about what the bill does not do, and then I'm going to talk about what the bill does. So, first of all, what the bill does not do, it does not defund the police. It does not grant anyone the right to assault first responders. It does not make it legal to inflict injuries on any first responder, and it does not change the law of malicious wounding in the Commonwealth. And there's been a lot of confusion in the public narrative about that. And I just want to explain to y'all what malicious wounding is, just so you have a sense of it, those of you who don't practice law, and how little it takes to be convicted of malicious wounding. You know, in the world of assaults, you basically have murder at the very top if somebody dies, and you have malicious wounding if somebody suffers an injury. Then you have assault and battery if there's a touching, an unconsented to touching that's done in an angry manner. Then you have an assault, which does not require any kind of touching whatsoever. Now, the Court of Appeals of Virginia has approved malicious wounding charges in many circumstances. And when you're dealing with a law enforcement officer victim, a malicious wounding charge carries a 2-year mandatory minimum sentence. This bill does not change that. This bill doesn't touch that. This bill doesn't have anything to do with that. So I'm going to give you some examples of things that will show you all you have to do, what little conduct it takes to get a 2-year mandatory minimum on a malicious wounding with a law enforcement officer. Burkeen versus Commonwealth, a 2013 case, the Court of Appeals found when somebody sucker punched a police officer that was enough to get a malicious wounding charge. Johnson v. Commonwealth, 2008, the Court of Appeals said hitting an officer with fists 4 to 5 times, which resulted in stitches and a sore shoulder, that got you malicious wounding, 2-year mandatory minimum. Commonwealth v. Perkins, 2018, 2 years ago, the Court of Appeals held that a single blow to the head can be sufficient to demonstrate an intent to injure and malicious wounding, 2-year mandatory minimum. In Conway v. Commonwealth, a case from Conway v. Commonwealth, 2015, the Court of Appeals held that a concussion can suffice for malicious wounding, 2-year mandatory minimum. Ramos v. Commonwealth, 2019, defendant struck the police officer only once. Police officer only once. That was enough to get a malicious wounding, 2-year mandatory minimum. English v. Commonwealth, 2011. Court of Appeals held to prove a bodily injury, the victim need not experience any observable wounds or cuts or breaking of the skin. And that's enough to get you a malicious wounding, 2-year mandatory minimum. This bill doesn't touch that. All those scenarios would still be malicious wounding after this bill passes. And also, you can charge somebody with an attempt to commit a malicious wounding, which is also a felony, such as throwing, say, a brick at a law enforcement officer. That could be attempted malicious wounding. Throwing some other type of solid, hard object, which could cause a cut or a wound, could be an attempted malicious wounding. So that's what this bill does not have anything to do with. So what we're talking about here are situations that involve much more insignificant minor touchings. And what the bill does, as amended, as it came out of the Judiciary Committee, is basically four things. First of all, if you look to line number 36 through 37, it eliminates a 6-month mandatory minimum sentence, number one. Number two, if you turn to the end of the bill, it says that in order, lines 97 through 102, that if a police officer would like to see someone charged with this felony infraction of assault and battery on a law enforcement officer, then they would have to get that situation investigated by an independent police officer. And then secondly, it would have to be approved by a Commonwealth attorney before the charge can be issued. A police officer still could obtain a charge for misdemeanor assault and battery, but if they want to elevate that later, then they have to do this independent investigation, get the police officer, to get the Commonwealth attorney to sign off. And the fourth and last thing the bill does, lines 38 through 42, it states that if after a trial, only after a trial, not at the beginning, but after a trial, if a judge or a jury finds the degree of culpability is slight due to the person's diminished physical or mental capacity or a pervasive developmental disorder, or if there's no bodily injury, the jury of the court can find the person guilty of a Class 1 misdemeanor, but only after a trial, not at the beginning. That's what the bill does at this point. And it's important that we do this for a couple reasons. Number one, first of all, with regard to the charging, the issues about how the charge is issued, this is the only offense in the books, the only one in Title 18.2 or in the entire Code of Virginia that I'm aware of, unless somebody can disabuse me of this, where the same individual is both the victim, the lead investigator, the lead witness, and makes the charging decision. So normally when a police officer investigates something, they're not the victim. They're not investigating themselves. They're not making a charging decision about something that happened to them. And so what often happens in these situations is the police officer gets very angry about what happened during an arrest. They end up in front of the magistrate, very angry about what happened, these charges issue. One of our law enforcement leadership said to me, came up with this idea about having a separate officer investigate the matter and having a Commonwealth attorney sign off, because they saw it as a cooling off period for cooler heads to prevail, for people to look at the scenario and decide whether or not this is something that really merited a felony charge. So that's important. Why? Because 70% of the situations where police officers are the victim of an assault in the Commonwealth involve absolutely no injury whatsoever to the police officer. And that's from the Virginia State Police annual crime report. There's about 1,900 assaults every year, assaults, malicious woundings, et cetera, where police officers are involved. 70% have no injury, 25% have minor injuries, only 5% have significant injuries. And of course, those are all malicious woundings or worse, right? So 70% of these have no injuries. And I'm sure you all have read in the papers about some of the scenarios that have been brought up where these charges probably should not have ever been brought. This bill had a problem almost the second it went into the books. In 2000, there was a case, Commonwealth v. Adams, where a student in school pointed a laser pointer at a police officer, an SRO, in his cafeteria. The police officer charged that student with felony assault on a police officer for hitting him with a laser pointer. The child went to trial, was convicted, was ordered to serve a 6-month prison sentence for pointing a laser pointer at a police officer in a cafeteria. The case went up on appeal to the Court of Appeals, and the Court of Appeals affirmed it. The Chief Justice of our Supreme Court, Don Lemons, wrote a dissent which basically said this is an absurd result. And he said, what's next? You're going to charge somebody with felony assault because they hit they turned their high beams on a police officer? He said, what's next? And shortly after that, Delegate Vince Callahan, who I'm sure there's a few people in this body are familiar with, but Vince Callahan introduced legislation in the next session to make assault on a law enforcement officer with a laser pointer a Class 2 misdemeanor because the legislature was so shocked that this could be an outcome of this statute. Then, a couple years later, in Commonwealth v. Carter, the Court of Appeals said that simply that an individual who was sitting in a car when a police officer walked up and they had their finger out and they said, "Pow," like that, that was sufficient to convict somebody of felony assault on a law enforcement officer and put them in jail for 6 months. And that's actually still the law today in this Commonwealth. So I'm sure you've read the examples about the situation where an officer got hit with an onion ring. I've had other people tell me about situations where a brownie got stuck to a food tray. An inmate pushed a food tray back through a slot. A thing of water fell down. Water fell on the correctional officer's shoes. That person got charged with felony assault on a law enforcement officer. There's situations, I have about 80 different anecdotes. Maybe we'd like to see them all. I'm not going to go through them all, but another one where an SRO asked the child to stay in a principal's office. Child didn't want to stay. They wanted to go back to class, walked by the SRO, shoulders bumped as they were leaving, got charged with felony assault on a law enforcement officer. The vast, vast majority of these situations don't involve any kind of injuries. They involve slight contact, and they shouldn't be felonies. All this bill does is adjust the punishment by getting rid of the mandatory minimum sentence and creates a cooling off period to ensure that these charges are brought when they really ought to be brought, when you're talking about somebody who's got a serious problem and maybe took a swing or tried to assault a law enforcement officer in a way they really shouldn't have, but not sort of incidental contact that really shouldn't be a felony. So that's what the bill does. I'm happy to answer any questions, but I would hope the body would pass the bill.
For what purpose does the senior senator from Chesapeake, Senator Cosgrove, rise?
Speak to the bill.
Senators, the floor.
Thank you, Mr. President. Ladies and gentlemen of the Senate, what in the world are we doing here? Have you watched television for the last couple of weeks? Have you seen what our police officers are going through? Have you seen the attacks on our police officers? And here we are with a bill that's going to actually make it easier on somebody to actually assault a police officer. Now, let me speak particularly to the laser incident that the gentleman from Eastern Fairfax brought up. Laser is very coherent light. And if you shine a laser, even a laser pointer, into your own eye or to somebody else's eye, it causes retinal damage. Permanent retinal damage. It's illegal to shine a laser onto an aircraft in flight, just even on the fuselage, for fear that the pilot may be blinded. But what we're doing here is we are just taking away protections from our law enforcement officers who are out there day and night trying to preserve, protect, and defend us every day. I have the greatest respect for the gentleman from Eastern Fairfax. He's a brilliant lawyer. But I will tell you, this is a bad bill. And I really hope that this bill does not go forward. And I really hope that if you do vote for this bill, you'll explain yourself to your own police force. Thank you.
For what purpose does Senator from James City County, Senator Norman, rise?
Thank you, Mr. President. I would ask if the gentleman who is a patron of the bill would be kind enough to yield for a question.
Will Senator yield?
I'll yield.
Yields. You have the floor.
Mr. President, the first part of my question is recognizing the extraordinary education that the senator got from James Madison University. I would ask if he is familiar who Prime Minister Disraeli was.
Senators, the floor.
I believe he was the Prime Minister of Great Britain right before World War II, if I'm not mistaken.
Further question?
I would ask the senator if he ever heard the phrase attributable to Prime Minister Disraeli that in order for remarks to be persuasive and memorable, they do not have to be eternal.
Senator has the floor.
Sorry, I'll yield again, but I didn't hear his question or statement
Senator,
or joke
repeat.
or whatever that was.
Speaking to the bill, Mr. President.
Senator has the floor.
Actually, the senator has put a lot of effort into remolding this bill, and I compliment him on it. But I think sometimes that the timing of when we address legislation and the perception that it creates in that time period are as critical as the substantive provisions of the bill. And I have less criticism of the substance of the bill than I do the timing that it is being advocated and the perception that it is creating. I don't know if anyone in this body has been in contact with the Virginia State Police. And if you have not, I would encourage you to contact the colonel and find out how many vacancies still exist in the Virginia State Police, but more importantly, how many resignations took place in the last week. Because of the chaos that is out there that is being generated by the mob in Virginia, I just don't think that the timing of this bill, as contrasted with the substance of it, is appropriate. It is creating a perception amongst law enforcement that we are backing up and diminishing the consequences. And I would further suggest that I think it would be more appropriate to take this bill up in the 2021 session when blessedly things have calmed down.
For what purpose is the senior senator from Virginia Beach? Senator D-Steph rise.
Mr. President, I rise for a question and would hope the gentleman from Eastern Fairfax would yield for a quick question.
Will Senator yield?
As long as it doesn't have to do with 1880s British parliamentary history.
Senator yields. You have the floor.
Mr. President, I promise it'll have absolutely nothing to do with 1880 parliamentary, whatever he was talking about. I will ask the gentleman, however, have you ever been in a situation where you've been trying to take control in a chaotic situation with mass hysteria, where you've had a laser shined in your light in your eyes, temporarily blinding you?
Senator has the floor.
As the parent of 4 kids, I've come close to that, but I don't think a laser was involved.
Mr. President, I ask a follow-up question for the gentleman from Eastern Fairfax.
Senator yield.
I'll yield.
Senator yield, you have the floor.
Have you ever been in a combat situation where you're walking down the street trying to provide a safe environment for the individuals who are trying to get to a voting establishment in a foreign country, or trying to get to a place where they could safely purchase food, and in a hostile environment where you have individuals trying to shine lasers into your eyes to temporarily blind you and take you off kilter?
Senator has the floor.
No, I'm not a combat veteran, so I wouldn't have ever experienced that.
Mr. President, speaking to the bill.
Senator has the floor.
Mr. President, our police officers go above and beyond to take care of us, to protect us, every one of us in this room. And on multiple occasions, multiple individuals in this room who signed on to this bill have asked our police officers from the Capitol Police and State Police for assistance and to protect them. Mr. President, I have been in a situation where I've been trying to protect someone or property and has a laser shined in my eyes, where I've temporarily been blind and not able to keep complete access and control of a situation. And Mr. President, we have to treat those who are put in the authority trying to protect us with respect, with dignity. And Mr. President, if we can help provide safety to those individuals when they're at risk and risking their lives to protect us, well then, frankly, we should do it at all possible costs. And Mr. President, if someone assaults a Capitol police officer who's protecting us, protecting our grounds, protecting our Capitol, and doing their job, and we know that the penalty for assaulting that officer is a minimum of jail time, then frankly, Mr. President, I think they should serve a minimum of jail time. And I don't think that their mental state, I don't think if they're had a drink or two and say, oh, I wasn't in complete control or I wasn't thinking, I don't think that should have anything to do with it. With the riots going on across our state and across this country, if you look at what's happening with lasers being shined into the face of individuals, police officers being pushed and shoved into harm's way, And frankly, if you're shining a laser into the eyes of our police officers, as our military individuals, I can tell you that temporary blinding is done for two reasons. One, to disorient that individual. Once disoriented, it's very easy to disarm or otherwise attack that individual. And Mr. President, I don't think that we should be lessening a crime where we could clearly harm one of our police officers and put them in additional harm's way just because we think that it should be okay to assault one of our police officers. And frankly, pushing somebody is just as bad as punching somebody under certain circumstances. These officers are there to control the situation and for the protection and safety of our citizens, and with our Capitol Police, our legislators. And Mr. President, I don't think we should lessen any penalties or any crimes that would help protect those officers who daily put their lives on the line to protect us. So, Mr. President, I hope we would not pass this horrible bill. I hope we would push it off and we'd put a little more thought into things like this in the future. And I'm happy to consult with the gentleman from Eastern Fairfax because I have had those combat situations. I have been put in harm's way, and I have had people shove me, push me, trying to disarm me, shine lasers in my eyes, and I've had things like that happen. So I'm happy to stand up and explain to the individual on any time he's got any questions on things like this, but I do not think we should even consider passing a bill like this. Thank you very much.
Thank you, Senator. For what purpose, the senator from Western Fairfax, Senator Marsden, rise?
Thank you, Mr. President. Speak to the bill.
Senator's floor.
Mr. President, all this bill does is provide guidance to police officers, magistrates, Commonwealth attorneys to separate the wheat from the chaff, the serious assaults versus the non-serious assaults, the things done in emotion and panic by someone who's being arrested. And I never thought I'd have an opportunity to discuss this on the floor, but you know, as a probation officer for 20 years, I had the authority of a police officer and conducted many arrests. And I didn't realize how many times I'd been assaulted, but it actually never occurred to me, given the level of those assaults, to even charge somebody with it. Those individuals were being arrested for something else and didn't need the additional duress, and none of the assaults amounted to anything that I would even consider somebody having to do 6 months for. So that's all this bill does. But let's think for a minute. We got to be smart about felonies. We can't just be handing these things out like candy because we pay the cost of felonies. If you're putting people in situations where they're being charged with felonies, you're limiting their ability to support their families. You're limiting their ability to pay child support. You are putting social costs on the citizens of the Commonwealth of Virginia for poorly thought out reasons. All the senator from Eastern Fairfax's bill does is provide the guidance so that we can separate those things that are serious from those things that are not. And I think in respect to the gentleman from Virginia Beach, I honor his service, and I know that laser pointers can be difficult, but a prank pointing something at somebody's chest versus a purposeful attempt to blind somebody are two different things, and we need to separate those two things out. And that's all this bill does. Is give people the tools to make better decisions that cost us less money, ruin fewer lives, and at the same time protect our police officers. Thank you, Mr. President.
Thank the senator. For what purpose, senator from Hanover, Senator McDougall, rise?
Thank you, Mr. President. To speak to the bill.
Senator has the floor.
Mr. President, as a JMU grad as well, I'd advise the gentleman from Fairfax that Disraeli was born in Middlesex, not the one that's here in Virginia, but the one that is in the UK, to add to his knowledge. But Mr. President, as we look at what we're doing, we've talked about one aspect of the bill, but we've not talked about the other. And the other aspect of the bill is this affects judges, magistrate, firefighters, and takes away the mandatory penalty for when they've been assaulted or battered. Certainly, Mr. President, the reason that we lay out in the Code of Virginia different individuals for this to be a Class 6 felony for is because we think, as servants of the public and in the capacity that they are oftentimes forced to be in, they're firefighters or law enforcement, they deserve a level of protection, and people need to know that when they assault them, that there is a penalty. Mr. President, we make lots of decisions here in this body, and certainly this is one that we are going to make today. But I think the senator from James City indicated it fairly eloquently. Right now, the actions that we are taking are sending a clear message to two different groups of people. One is to law enforcement. That message to law enforcement is that we don't care about you. We don't care about your sacrifice. We don't care that when there is trouble, when there are problems, when we're in distress, that regardless of whether you want to be there or regardless of how dangerous it is for you, we don't care. Mr. President, we're also sending another message. We're sending a message to people that riot in our streets, a message to people that destroy our property and put our families at risk, that if you encounter a law enforcement officer, you don't need to be concerned. Because if you assault them, it's not as serious. Mr. President, this body has a choice to make going forward, and that choice should be to send two messages to law enforcement: that we appreciate your service, we thank you for being there, we thank you for coming when it's not convenient, when it's not safe, for being there for us. And Mr. President, we should also be sending the message that when you're in a situation, you don't assault people that are there to help you. You don't assault firefighters, you don't assault law enforcement, you don't go after judges, you don't go after magistrates. That is not acceptable, and if you do, we're not going to debate it or discuss it. You're going to go to jail.
Thank the senator. For what purpose, the senator from Lynchburg, Senator Peake, rise?
Yes, sir. Thank you, Mr. President. I rise to speak against the bill.
Senator's floor.
And thank you, Mr. President. And I don't think there's anyone in this body or in the House of Delegates or really, frankly, in the Commonwealth of Virginia that saw what that officer did to George Floyd several months ago did not think that that was horrendous, horrific, and something needed to be done to that officer. And similarly, when I look at what that officer did in Wisconsin 2 nights ago and shot a person in the back while he was walking with that person and did not detain him, did not tackle him, instead just kept walking with him, and then when the individual got to his car and tried to get in, shot him in the back. I don't know how you justify that. I know there's some more videotape and the suspect may have been involved in something, but I don't think there's anybody that thinks it's okay for a police officer to shoot an unarmed person in the back. Fortunately, none of these events have occurred in the Commonwealth of Virginia. And when the governor called this special session, he called it to address the budget shortfalls we have because of the pandemic. And then he did it for social justice reform and criminal justice reform and police reform. Well, none of those events happened in the Commonwealth of Virginia. In fact, we didn't have any problems with our law enforcement. There were 1 or 2 events here and there over the course of the past 3 or 4 years, covering 8.5 million people, with numerous contacts, law enforcement contacts with individuals. But these issues, these horrible issues, did not occur here. These deaths did not occur here. These shootings did not occur here. And there was a nationwide movement, defund the police. We need to get rid of the police departments, defund the police, where the folks around here, the Democrats in Virginia, realize that's not a really winning argument. So we've heard numerous times that we're not here. These bills are not about defunding the police. I mean, we heard it last week until, of course, Delegate Carter yesterday put forth his bill to defund the police by 25% state police and 25% aid to local police. That, in my book, cutting their funding by 25% is defunding the police. And the governor said, well, we're not going to defund the police. We're just going to take that money and use it elsewhere. You know, that sounds like defunding the police. Maybe y'all are not here to defund the police. But I tell you what, all of these bills that have been put forth, they might not be defunding the police, but they are damn sure demoralizing every single law enforcement officer in the Commonwealth of Virginia. I hear it every day when I go into court from the bailiffs. My God, if y'all pass that sovereign immunity bill, I'm out of here. And I just got a, while this debate was going on, I got a text from a law enforcement officer formerly of Goochland, now somewhere else. I'm not going to quote him because he doesn't know I have it. Well, I'm going to quote him, I'm not going to give his name. After 11 years, he's retiring. And it's not because he couldn't accept the risk presented in his profession, not the risk of death or disfigurement. He accepted that like every other police officer. Why he's leaving after 11 years is I could no longer accept the risk of being character assassinated, fired, sued, arrested, or all of the above for acting completely and appropriately and in good faith during the course of his duties. And the senator from Eastern Fairfax, Senator Sorrell, who is a fantastic lawyer, civil and criminal, and he's correct on some of these assault charges that have been brought against criminals assaulting police officers. Some of them are ridiculous. But I tell you what, there's somebody a lot closer to the people than we are that should be addressing these matters, and they're the Commonwealth's attorneys in those localities. They have to answer to the people every 4 years. They have to answer to the police officers. They have to answer to the citizens groups in their communities every 4 years in a public election. That's who's responsible for pursuing some of these bad cases. They can be resolved at the local level. They should be resolved at the local level. But we've got this assault case, and the senator from James City County, I think, brought a good motion. We are in the heat of battle right now, responding to national crisis not involving the Commonwealth, and we're bringing sweeping actions in the blink of an eye without having time to think about it or for cooler heads to prevail. Kind of like what happens to a police officer on the street at night when he's facing multiple people and he thinks his life's in danger or his partner's life's in danger or an innocent civilian's life is in danger. He has to make split-second decisions. We don't have to do that. We've got till next session. We're coming back in January. We can give folks more time to weigh in. We can let this sink in. But I tell you what, during times like this, when they're rioting in the streets of Richmond and throwing bricks and doing things like that and breaking out windows and looting and destroying small businesses, the last thing we need to do is further demoralize our law enforcement officers. And one of the ways we do that is by saying, don't worry, you can cuss at them, you can yell at them, you can swing at them, and it's just a misdemeanor with no jail time. That is not the message we want to send to our law enforcement officials. And if you respond, if somebody does this to you, you are now personally responsible. We're going to take away your immunity and hold you personally liable for you acting in the course and scope of your duty as a law enforcement officer for all the citizens of the Commonwealth. Now you're going to be personally responsible for any injuries or damages that may come about as of that. And, you know, you may be acting in split seconds, milliseconds. Somebody have a gun, somebody have a knife. They're going to kill somebody. They're going to kill me. Am I going to make it home? Is my partner going to make it home? But now we're going to form these committees of non-trained people who have no experience in the business, and we're going to put them in charge of making sanctions or firing them or overseeing them. Those are the things we're going to do. Those are just some of the bills that have been brought in this special session to demoralize the police. And we've got things we need to take care of. We've got the pandemic. We have budget holes in our budget. That's what we should be focused on. That's the only emergency that we have in the Commonwealth right now. That's what we should focus on. Leave our hard-working law enforcement officers alone. They do the best they can every day. They risk their lives every day. Their families worry about them every time they walk out of the house. And the last thing we need to do is to pass a bill like this that tells them, you know, you're not as important as we think you are, or you think you are. You're going to be responsible. You can be assaulted. So I ask that we vote against this bill.
Thank the senator. For what purpose, the senator from Northwestern Fairfax, Senator Boysko, rise.
Thank you, Mr. President. I rise to speak to the bill.
Senator has the floor.
I appreciate my good friend for bringing up all issues surrounding anything that might possibly happen in Virginia relating to the police. However, we're talking about a very specific instance in this bill. I would like to bring the attention to the body to a portion of the bill. It is the fourth paragraph, I believe, that clarifies who we're talking about. Any person charged with committing an offense in violation of this subsection where the degree of culpability is slight due to such person's diminished physical or mental capacity or pervasive developmental disorder. If there is no bodily injury, a jury or a court may find the accused not guilty of violating the subsection, but guilty of a simple assault or assault and battery in violation of subsection A, punishable as a Class 1 misdemeanor. This piece of legislation is specifically targeted to the people who are intellectually and developmentally disabled. And every single one of us have a number of constituents in our communities whose families have had really unfortunate interactions with the criminal justice system. I have reached out to people all over the state to hear from them, to hear their personal stories. I know that there's a family in southwestern Fairfax whose son has a problem spitting, and he had an interaction where he spit on the officer. He has what's called PANS syndrome and got into trouble. This is the kind of thing we're talking about. I have another constituent in Loudoun County. I've been working with the ARC of Northern Virginia and with Virginia as a whole, and have received so many stories from people who did not have the capacity or the ability to control themselves, who didn't have the understanding of what they were doing when they slapped a policeman, who didn't have the understanding or the capacity to realize that what they were doing was inappropriate, even though it was against the law. That's what we're talking about here. There is not one person in this body who wishes to disenfranchise the hardworking police officers and sheriffs in our Commonwealth. We worked hand in hand with the chiefs of police, with the sheriffs, with the state police to talk in advance over the past 2 months to discuss what our policies were going to be and to make sure that we weren't going to have unintended consequences. This is an important piece of legislation for the families who are members of the ARC, who have intellectual disabilities and developmental disabilities. This is not gratuitous or frivolous or in any way disrespecting our police officers. This is saying that there are some people who are different and deserve to be treated differently, and by sending them to jail on a felony will not make anything better, but in fact will make things worse. Thank you, Mr. President.
Thank the senator. For what purpose does the senator from Prince William County, Senator McPike, rise?
Thank you, Mr. President. Rise to speak to the bill.
Senator has the floor.
Thank you, Mr. President. You know, as a firefighter over 20 years, you know, this bill would apply to many of those I've served with over the last 2 decades. And so when the original draft came out and was discussed, I had some level of concerns. And so what do? I went and met with some of my local police officers, the folks that are on the street, about the various issues. And as originally written, you know, they had concerns about essentially doing away with the assault on police officer portion of this. That's not what the substitute does, thankfully. After that discussion, and the senator from Eastern Fairfax was there as well, and a small group discussion over sort of the mechanisms of what happens. And what was illuminating to me was the officers sort of described, we went through different scenarios, and one of them was sort of the minor scenario of you get sort of tapped on a hand, or other minor things where it's not, someone didn't take a swing at you, someone didn't try to take you out. And what they told us was, as they write up the report and they go to the magistrate, anything like a slap on the wrist or a slight touch of the officer would still fall under the old law that's now being proposed to be changed. And so they would have to charge him with a felony, even if the officer didn't feel that it warranted. But based on the description of the events to the magistrate, the charges would be filed at the felony level. Felony has serious impacts on the lives. And so as we work through the issue, we started to identify maybe a different approach that still empowered officers, and that's what the substitute before you does, is offers a different venue and different alternative for the officer to still bring a misdemeanor charge or other options, just helping to distinguish and give guiding factors to officers as well as the magistrate. Some of the demoralization comes from the sensationalization from the other side of the aisle, the sensationalization of some of these bills. If you actually talk to your constituents, which I think is all of our responsibility to do, in practice of how the law is applied, then we can have some meaningful conversation across Virginia. And I think that's important to do today, especially now on the important issues that we face. So as originally written, I think we had a number of different issues. As this is now proposed, I think actually empowers officers to make more clear choices in terms of the depth of what occurred, as well as a safety check in terms of taking the time out, going to the Commonwealth Attorney, having another person take a look at it, since it is the same person that's bringing charges was also the victim. Now, this sort of distinguishing and separation, I think, is good practice. I think it's a good framework. If a serious assault, as I told the senator from Eastern Fairfax, does occur, I want them charged with a felony. If they take a slug at some of the people I've served with over 20 years, I want them charged. And I want them to go to trial. I want them to do the time necessary. One of the few times I've missed session here in the General Assembly during my time was for a funeral of an officer. So I take this very seriously. But after sitting down and talking to the officers, those who serve on the front lines, this bill actually achieves and gives them tools to better distinguish when they don't feel that a felony should be assigned. So I want to make sure that the other side of the aisle takes their conversation and their communities a little bit more seriously than just blowing smoke for the media. Thank you, Mr. President.
Thank the senator. For what purpose does the senior senator from Richmond City, Senator McClellan, rise?
Thank you, Mr. President. Speaking to the bill.
Senator has the floor.
Thank you, Mr. President. We've heard a couple of times that we're taking action based on things that happened in other states. I'm going to tell you a story about something that happened here in Virginia to Caleb Moon Robinson, who was 11 years old in the 6th grade in an elementary school in Lynchburg. He's an African-American autistic child who has sensory issues. And many autistic children, when you touch them, they panic or they react. Caleb had already had a run-in with a SRO when he was disciplined, sent to the principal's office, and on his way out the door, he kicked a trash can, and he was charged with disorderly conduct. Then there was a rule put in place, just for Caleb, that when other kids left the room, he had to wait. He didn't follow that rule, and that same SRO came and grabbed him while he was drinking out of a water fountain, and Caleb panicked. He didn't know that officer was there to help him. All he knew was that someone grabbed him, and he cursed, and he struggled. And that officer threw him on the ground, handcuffed him, and he was charged not only with disorderly conduct, with felony assault on a police officer. And under the current law, convicted of that, there's no way that a judge or a jury can look at the circumstances of that case and decide maybe 6 months in jail is inappropriate. Now, we put legislation in to try to address similar issues. I had a bill last year in regular session that just asked the Secretary of Public Safety and the Supreme Court to make accommodations and put policies in place on how to deal with situations like Caleb's or like some of the ones identified by the senator from one of the Fairfaxes. That was referred to the Crime Commission for study, who, based on their workload, decided not to study it. So another year would go by, at least, where autistic individuals, people with intellectual disabilities, people with developmental disabilities, people in the middle of a mental health crisis who don't know a law enforcement officer is there to help them, who barely touches them because they're in the middle of panicking. There's a one-size-fits-all punishment that doesn't fit that crime. That's the problem with mandatory minimums. This bill does not repeal the felony crime of assault on a police officer. It does not repeal that crime. It repeals the mandatory minimum so that we can trust our judges and our juries to look at the facts of the case and decide, is the punishment proportionate to the crime? And that is part of what people are marching in the streets and demanding change for. Because for too long, in this Commonwealth, there have been cases where the punishment is disproportionate to the crime, and in some cases will ruin an autistic kid's life. How long do we have to wait to change that? We know the situation. And the time is now to do something about it. This is a very narrow bill to address a very serious injustice in our criminal justice system. And I ask that we pass it.
Thank the senator. For what purpose does the senator from Franklin County, Senator Stanley, rise?
Thank you, Mr. President. Speak to the bill.
Senator's floor.
First of all, members of the Senate, Mr. President, I don't think anybody on this side of the aisle in arguing against this bill is blowing smoke for the media. If anything, it seems to me that we're kowtowing to the rioters, to lawlessness. Why do you ask that? How could we dare do that? Well, I don't know. Last night as I watched the TV, as the riots continued in Wisconsin, this is the exact words I heard, except I'm going to have to clean it up. Kill the effing police. Over and over and over. Kill the effing police. If you don't believe me, just go to one of these pedestals of these monuments and read it. Do you think these are just quippy sayings? Quippy sayings of the rioters to just blow smoke at the media? I think not. Rather, I think it sends a clear message of the intentions of those people. Lawlessness, rioters. I've been a criminal defense attorney since I passed the bar in October of 1994. I've represented thousands of criminal defendants before the bar in the Commonwealth of Virginia and in other states. What I have found through my conversations with them, because a lot of times when they come to me, they've committed a crime, there's underlying problems. I try to help them, I lecture them, I support them, I push them, I defend them, I fight for them. But they do understand, very specifically, that if you touch a police officer or a first responder, you're going to jail. It's called deterrence. And as many of you have stood on this floor previously, we need this bill for deterrence. Well, this law is already in place for deterrence. Many of my clients know. Don't touch a cop. You're going to jail. It's felony, mandatory minimums. Many times when that has occurred and the charge has been placed, there are times where we all, including the victim who is bringing the charge, as that's some weird thing that never happens in the Commonwealth of Virginia, because we have civilian complaints where I can walk in tomorrow and say, Scott Suravel assaulted and battered me, have no Commonwealth attorney, no police officer, and I am the victim bringing the charge. Bringing the charge. That doesn't matter. But when every time this has occurred in my practice in 26 years, and I know it's happened in others, you sit with the Commonwealth's attorney, you even sit with the police officer. They describe to you exactly what happened. And if it does not rise to the level, then other arrangements are made, less than a felony, less than a mandatory minimum. You know, in all those times that I talk to my clients, and believe me, I'm known as lecturing them quite extensively about changing their lives, about doing better, about obeying the law. When we say obey the law, we also say respect the authority that comes with it. Because they are symbols of abiding by the law. They are the symbols of government, and they are those that are out there to protect us and to help us and to enforce the laws that you all have put on the books when it is broken. And when I'm having those conversations with my clients, and they want to complain, he pulled me over, searched my car, found marijuana. Well, why'd he pull you over? Well, I was speeding. Well, guess what? Don't speed. If you don't speed, I advise my clients you don't get pulled over. I've had clients come to me and say, he roughed me up a little bit, we got into it when I was arrested. The funny thing is that if you don't resist and you comply with the orders, whether they be right or not is to be determined in a court of law later, or whether that police officer did right or did not do right when they arrested you, comply. I tell them, just comply. And then there won't be a problem. Even if they're not just in doing it, that's not going to be determined on the road or in the field or in the yard. Don't run, don't resist. Because that's what I'm here for. That's what the senator from Eastern Fairfax is here for. That's what the senator from James City County is here for. That's our job. And if there's a constitutional violation or a violation of any one of the rights of that defendant, then a good lawyer is going to fight for that client like me, is going to make sure that the police are held accountable for it. That's justice in a courtroom, because we respect the rule of law, which starts with us in the legislature. Those laws are made, those laws are enforced by the police, and those laws are then judged in courtrooms. That's respect. And when you're telling my potential clients, my former clients, or people out there, hey, you can beat up on a cop, it's a misdemeanor. That word will spread, and what you will find is not a greater respect between police officers and those that they come in contact with. You'll find that there is less respect on the side of the person who may have committed the crime. There may be more emboldenment for them to do more and to resist more than they would otherwise have, because this law, in its current form without changing, acts as a deterrent. So forgive me, forgive all of us on this side of the aisle who believe passionately in the rule of law, who believe unequivocally that we must show respect as we were raised to authority, even when that authority is overreaching or illegal. Ladies and gentlemen, this is not blowing smoke for the media. This is fundamentally changing a law that will have an effect on the ground that I will see and every other criminal defense lawyer will see. And the erosion of the lack of respect for those that take care of us in our police and our first responders. That's why we think this is not a good bill. And that's why, Mr. President, I urge everyone to vote against it. Thank you.
Thank the senator. For what purpose, the senator from Arlington? Senator Favola, rise.
Speaking to the bill, Mr. President.
Senator has the floor.
Thank you, Mr. President. I am pretty surprised by the debate we've been listening to this afternoon. During my 8 years in the Senate, and I know it's nearly not as long as many of you have served, but I've heard very eloquent speeches from our lawyers here. And just about every speech, there was a nuance. There was an argument that not every case is equal. There are mitigating circumstances. We have to amend this bill. You don't understand the complexity of all the cases that come before us. My hat's off to you. I now ask you to think about those arguments you used to make for all these other different cases, and now we're talking about making our justice system more fair. Not every offender is equal. We are not talking about removing the felony charge. If there is an aggressive assault on a police officer, that charge is there. What this bill does is acknowledges that not every offender is going to be aggressive, intentional, and harmful to a police officer. In fact, there are offenders, so-called offenders, who are out there who don't understand fully why they're being stopped, who don't have good communication skills, who, yes, they do have diminished physical and mental capacity, and they are not aware of the situation. I would hope we have some compassion in our heart to allow a court and a jury to find another tool to say, okay, we understand there was a mitigating circumstance, which if I hear that word again from you lawyers, I'm going to have you explain it to me one more time. This is another tool. As I read it, we still have a simple assault or assault and battery, a Class 1 misdemeanor. That's still available. This bill in no way disrespects our police. This, in my mind, really articulates in a better way how we want our justice system to work. I really hope that this body finds it within their heart and soul to vote for this bill. And I thank the senator from Eastern Fairfax for bringing it forward and for all the collaborative work you did with the police and the other associations who are involved. Thank you, Mr. President.
Thank the senator. For what purpose, the senator from Henrico? Senator Donovan, rise.
Thank you, Mr. President. I rise to speak to the bill.
Senator has the floor.
Thank you, Mr. President, members of the Senate. Many years ago, I was driving my kids to school in carpool, and I was late, which may not surprise any of you. And I got a ticket. I'm a little embarrassed to tell you guys that, but I did. And I had an officer walk up to my car and ask me for all the documents that he needed. And as you all know, I am a military brat, and I have an enormous amount of respect for a uniform. Always have and always will. And as that officer asked me, knowing fully that I was responsible for the error in breaking the law, I complied with everything he asked. I said, yes, sir, as I do to many of you, and I always did to my father and my family. And when he brought back the ticket to my window, and this was a young African-American police officer, when he brought the ticket back to my window, he said, "Ma'am, the neighbors called us and asked us to put a speed trap in this neighborhood, and I'm going to have to give you a ticket because of that circumstance. But if it were within my power, I would not give you this ticket because you have been so polite to me." I was floored. I was heartbroken. And when my window closed, I stopped and I said to my children how important that was. And this was an opportunity for them to learn that when people serve us and when they wear a uniform, they deserve our respect. They're not perfect. They're bad police officers like they're bad doctors, but the uniform commands respect. Many of you know I have a brother that was a law enforcement officer for 11 years. I have a nephew now. I talk to law enforcement quite frequently. I will point out, as we debate this bill, the arguments I hear often stray far from the subject matter of the bill. And I would agree with the senator from James City County that there are some merits in the bill, but it's not quite as it's been described to us today. But I will tell you that in the time that my brother was a police officer, which was only 11 years, he was injured so many times in his practice of law enforcement that I can't even tell you how many. I know he went to the emergency room 11 times, and he knew all the emergency room nurses by name. And he had serious injuries. And I think as we debate this, we need to understand, yes, with any law, there are times that any inappropriate things are brought forward, like the mild cases that have been mentioned here today, but those laws are needed for the very serious cases which continue to happen. And I will point out, when we say so much discretion is needed by judge and juries, well, we have discretion in our Commonwealth attorneys. And Commonwealth attorneys can decide if they actually if they actually proceed with the prosecution or not. When we want to talk about developmental delay or other needs, and I don't have the bill in front of me now, my computer's gone out, but if you look at that paragraph very carefully, it says or. And it says a slight infraction. Well, what the heck is that? Who's to say that's subjective? That is not a defined entity. It says it has several other issues in that particular paragraph that are subject to interpretation, and that interpretation may vary greatly from person to person. And it is that gray uncertainty that makes it important that we are certain with the bills and the law that we have, and that we protect people who serve us in law enforcement in a uniform, allowing discretion of whether or not it's inappropriate where it belongs with a Commonwealth attorney. I will point out, too, there's legislation that has come before this body to actually target specifically the issues of developmental challenges in law enforcement, and I've carried it myself, and it has failed. And we have sought to make sure that there is screening of developmental delays. That is how you address that issue, not a bill that has to do with the police. I will point out also that I think as we have conversations, we need to have a high level of mutual respect. I assure you, I am in close conversation, not only with my family that are in law enforcement about the bills we're looking at, but at the law enforcement officers in my district. And all the bills before us now concern them. This bill does not aspire to accomplish what we've heard. It is not going to correct the injustice of unequal implementation of law. There are bills that we can pass that will do that, and there is work to be done, but this needs to be an authentic conversation. When I hear this talk about media, and we're inciting the media, I'll point out, my friends on the other side of the aisle, they rarely publish what we say. They often publish what you say, so we're not getting a big Cracker Jack media event here. We're simply stating the truth. And the truth is that at this moment in time, this bill is too obscure. It undermines the certainty that our law enforcement officers deserve. It does not accomplish the goals that we have been asked to accomplish in criminal justice reform. And as such, it is a pretty big insult to our law enforcement community when they're doing what they're doing. I propose that we do not pass this bill today. It is better entertained in session 2021. Thank you, Mr. President.
Thank the senator. For what purpose is Senator from Hampton? Senator Locke rise.
Thank you, Mr. President. Can you hear me?
Can hear you, Senator. You have the floor.
Okay, thank you. Mr. President, what I've been hearing up to this point has devolved into, if you support this bill, you are anti-police. And if you support this bill, you support mobs and people who are violent and out there rioting in the street. At least that's what I think I've heard. Well, Mr. President, I interpret that as a lot of hyperbole. I interpret that as, once again, changing the narrative to fit an agenda. And also, Mr. President, I have heard we need to kick this can down the road to the 2021 session. Let's just wait, until, we can fix this. Well, Mr. President, there's nothing wrong with this legislation as it is right now. I believe that Martin Luther King said in his letter from a Birmingham jail that we're always being told to wait. And I believe that the senior senator from Richmond said something about wait, that we're always being told to wait. Well, Reverend King said that wait almost always means never. Well, now's not the time for never. We're dealing with the urgency of now. And I do not condone the violence in the street. I certainly don't support mobs. But when you hear about people being shot in the back, unarmed people, or watching somebody get choked to death on TV, I do understand the rage. It's 401 years of rage that somehow has bubbled to the surface. So we can't kick this can down the road. And we need to deal with the substance of the legislation, and not engage in stuff that the bill is not about. And then we hear that, we're talking about stuff that didn't even happen in Virginia. The senior senator from Richmond already talked about a case. Well, I have a whole list of them, but we're not going to go through them, But if somebody wants to see them, I have them right here. If we want to talk about stuff that happens in the Commonwealth of Virginia. Virginia's not immune from what happens in other places. So let's deal with the issues right now. That's why we're dealing with them. And maybe if we wait until stuff calms down, well, maybe if we address these problems now, and let our constituents out there know that we hear them, that we've been listening to what it is that they've been telling us that they want done, things will calm down. People would know that we hear you. We know what it is that you want, that we understand what it is that's going out there. If you bump into somebody, you get an assault charge on your record. You get a felony on your record. We hear you. We understand. We want to address these issues. So that's what this is about. And that's what this bill is addressing. Thank you, Mr. President.
Thank the senator. For what purpose is the senator from Alexandria, Senator Eben, rise?
To speak to the substitute.
Senator has the floor.
I feel like I'm in bizarro world today. I'm not sure what bill is being described on the other side of the aisle. But I thought that the senator from Eastern Fairfax described his bill accurately with the words on the page that I read. I'm not sure what bill the senator from Lynchburg was addressing, but there's no measure filed, to my knowledge, to defund the police in this chamber. I'm confident if one were to arrive in this body that it would not see this floor. We support the law, the rule of law, of course, any implications otherwise to the contrary. And we respect and appreciate our first responders. But this bill has a lot to do with our Commonwealth attorneys. The Commonwealth attorneys were referred to as having discretion from the senator from Lynchburg and also the senator from Enrico. But I want to make sure the body is aware that Commonwealth attorneys representing 45% of our state's population have publicly endorsed the bill. Those are the ones who publicly have done it thus far. It provides them with the flexibility to do their job properly while still keeping in place provisions to cause serious repercussions for those who would do violence to the police. And you know, it's good to be respectful of the police at all times. It's good if you get a traffic ticket to be polite. But if you touch a police officer by accident, or as someone who just texted me, a mom of an autistic boy, you know, if someone who's got diminished capacity touches a police officer and doesn't cause serious injury, should they really have a mandatory minimum sentence? So, you know, the last thing I'll just close with is one thing the senator from Lynchburg said was that the senator from Eastern Fairfax, if I heard him right, was essentially correct about many of the provisions in his bill. So I agree, and with that, I encourage you to read and understand the words in the bill and vote for it. Thank you.
Thank you, Senator. For what purpose, the senator from Russell, Senator Chafin, rise?
Mr. President, I rise to speak to the bill.
Senator, has the floor.
As I've heard all of my colleagues talk and comment about this particular bill, I have wondered in my mind, the question that keeps reverberating through my head is, why is now the right time for this bill? And why is now the right time for these so-called reform the police and law enforcement bills? Some might say, well, and politicians do like to do this, I'm told, to give lip service to a particular subject. But, Mr. President, this is not just lip service. So I dug a little deeper and I thought, well, we have a lot of laws on the books in the Commonwealth. Laws like, and for example, if an adult touches a child of a certain age, that law is considered, that act is considered so repugnant that it will not be tolerated, and there will be a prison sentence. So I wondered a bit more, and I wondered, well, why is it that police officers, magistrates, judges, correctional officers, firefighters, emergency service providers, why is the touching of them not repugnant when they are trying to do their job? Why is that not repugnant? Why is the laying hands on those individuals not repugnant to society, not repugnant to members of this chamber? And as I worked my way through it, I thought, well, what do they have in common? What do this group of individuals that I just named that are in this bill, what do they have in common? Are they all getting rich? No, they're not there to get rich. Are they all somehow committing wrongs? No, they're not all somehow committing wrongs. Well, I'll tell you what they are doing, Mr. President. They are serving us. They are serving the citizens of the United States, and they are serving the citizens of the Commonwealth of Virginia. And in 99.9% of the time, they are serving with distinction. That is what they are doing. So I thought a little bit more about it, and I thought, why are we making it harder on this group of individuals that are serving with distinction 99.9% of the time? Why are we doing that? And the only reason that I can come up with, Mr. President, is because because of the timing, because of the timing, because of the timing. And I think that right now, the timing suggests to me, and no doubt this bill has been made better than it started out, but the timing suggests to me that the intent is to deter law enforcement. And it will no doubt have that effect. The intent is to deter it. I have been in conversations with dozens of law enforcement officers, and they all say, you know, Ben, it's really hard for us to recruit. It's really hard for us to get guys to come work for the sheriff's office. It's really hard to get new recruiting classes. And we're just not seeing it with all this going on. You know, 2 years ago, we had 20 people in a recruiting class. Now we're seeing 2 and 3. We've got shortages all across the Commonwealth. So why is now the right time? We all need to ask ourselves. We all need to ask ourselves that very question, Mr. President. It seems to me that now is not the right time. It is not the right time. We should honor, we should respect those who honor and respect us with their service. Right now is the time that we should give those who respect and serve us, right now is the time we should give them the respect that they so richly deserve, and we should vote against this bill. Thank you.
Thank the senator. For what purpose is Senator from James City County? Senator Norman rise.
Thank you, Mr. President. I recognize that I previously spoke, and I will try to be succinct this time and reduce it down to a phrase or two. I would have to say that I agree with the young lady, the senator from Hampton, that no one is suggesting that any member of this body is anti-police. I am suggesting, going back to my initial remarks, that because of the timing and the perception, we should gently, not kick, but gently carry this bill into the 2021 session. I would remind the body from a timing standpoint, I am certain that almost every member of this body saw the disgusting, vile, inflammatory flyer that called for a gathering just 36 hours ago here in Richmond, and what it said about law enforcement, the Virginia State Police and the VCU Police. I would further say that the perception to diminish the laws as it relates to law enforcement at this time in any way is a bad perception. It is an issue of timing and perception. I would say, Mr. President, I've listened to some of the comments and I have chagrined at one in particular. But I think one of the strengths of this collective corporate body is that we bring a diversity of talent and life's experiences into this body, and that we attempt in the civil discourse in a collegiate manner on policy issues to enjoy the benefit of different perspectives. As I reflect on it, I have been practicing law longer than any individual in this body. And I have spent almost my entire career, not as distinguished as some, but almost my entire career as a criminal defense attorney. What I know about law enforcement is not through some vicarious experience, not by conferring with some social worker. I talk to these ladies and men 5 days a week in my professional capacity. I represent a law enforcement body. I have a continuous and respectful dialogue with them, and I know what their perceptions are. And that is what I am concerned about. I would suggest to you, Mr. President, that there's some very important words that are not being embraced as I've listened to some of the comments. Prosecutorial discretion, judicial discretion, incapacitation as it represents a defense, juvenile and domestic relations courts, where young people are treated very differently, even on felony charges, than adults. Those are operative words. And I would suggest to you, Mr. President, that I think when we come in here, that one of the things that distinguishes us from the House of Delegates is that usually we enter into a collegiate discourse even when we disagree on policy issues. And for someone to tell me, who is in contact with law enforcement 5 days a week, that the position that myself and my colleagues who are experienced in this field take because of some smoke and media situation, I take offense at that. I take offense at that because I live professionally with these people every day. So I just respectfully encourage the body, and I know I'm not convincing a soul, and everyone in here knows that, but I respectfully encourage the body to gently carry this bill over into 2021.
Thank the senator. Any senators whose microphones are still on, if you check your red light, just want to make sure that your mic may be turned off. For what purpose is the senior senator from Chesterfield, Senator Chase, rise?
Thank you, Mr. President. I rise to speak against this bill.
Senator, has the floor.
Thank you, Mr. President. One of the biggest concerns that I also have about the bill, we had mentioned earlier that there are 2 messages being sent. I would argue there are actually 3 messages being sent with this bill. The first message that we mentioned was being sent was to our law enforcement. And in such a climate, I also agree that this is an attack on our law enforcement. Any measure that we pass today that makes the role and the job of law enforcement more difficult is one that we need to reject. 2, we're sending a message to the criminals, and I just agree with the sentiments of a fellow senator earlier today. We're sending a message to criminals that we're going to stand back, like what happened in Richmond when Mayor Stoney stood back and allowed for the destruction of Richmond, stood back and did not allow law enforcement to do the job that they were trained and know how to do. Mr. President, I would argue that there's a third message that is also being sent today, and that is to our law-abiding citizens, to the business owners, the legacy business owners in the city of Richmond and throughout Virginia, that we don't care about their lives, that we don't care about the law-abiding citizens, Lord, because we're more concerned about protecting criminals than we are justice for the victims. Mr. President, I would like to take a look at line 40 of this bill. And in that bill, there are a couple things that I would like to bring to the attention of the body that concern me, that have to do with the vagueness of the language. It says, any person charged with committing an offense in violation of this subsection where the degree of culpability is slight, due to such person's diminished physical or mental capacity. Mr. President, there is so much room for interpretation. This is such vague language. Are we talking about someone who's strung up on drugs or alcohol and cannot make good decisions? And are we giving them a pass or a loophole through this very legislation that's supposed to help the disabled? I have grave concerns over that, Mr. President. And for that reason, I am standing with our law enforcement today and opposing this legislation. Thank you, Mr. President.
Thank the senator. Do any senators other than the patron wish to be heard regarding Senate Bill 5032? Seeing none, Senator from Eastern Fairfax, Senator Surville.
Thank you, Mr. President. Speaking to the bill.
Senator, has the floor.
First of all, Mr. President, I want to apologize to the body for taking so much of your time today. Sure, nobody else wants to speak. Number one. Number two, I just want to tell everybody that if anybody else compliments my lawyering skills on the floor, I'll give you a half price off your next speeding ticket. Anyone? Senator Donovan? No? Okay. So, a couple things. let me just clean up the record here. I don't think we're changing anybody's minds at this point, but I just think we need to be clear about a few things before we move on from this. Heard a lot about lasers. Lasers, pointing a laser at a law enforcement officer is a Class 2 misdemeanor under 18.2, 57.01. If you don't think it should be a Class 2 misdemeanor, get your own bill. That's for another time, another day. Ain't part of this bill. Delegate Vince Callahan took care of that back in 2004. Get another bill. Number two, ostensibly this bill is about, talks about judges and magistrates. I cannot tell you the last time I heard about a judge or a magistrate getting assaulted while in their robe or in their professional function. As far as I know, that pretty much never happens. And I would submit that that's not because there's a mandatory minimum. It's because people know you don't hit a judge or a magistrate, and they just don't do that. Oftentimes when they're in there's a lot of law enforcement around, or people are in handcuffs when they're seeing a magistrate. It's just not a thing. So what we're really talking about here are mainly firefighters and police, and mainly law enforcement. Nobody here is trying to send any messages to criminals. Nobody here is trying to stand with the people that don't abide by the law. That we're not trying to send a message to the police that we don't like them. That's not what this is about. We've tried to make that as clear as possible. In terms of the timing, this is part of the law enforcement reform discussion that's going on right now. And if you ask anybody who practices law, what they will tell you is that you often see these charges coupled with situations where an arrest becomes unnecessarily aggressive. And that happens more often than it should. And there's a lot of reasons for it. One reason is because of some of the things that we're going to be voting on next week. The police reform bill that the senator from Hampton is carrying, that's going to help solve some of those problems. But also another reason that these over-aggressive arrest situations don't often get addressed is because the person who's the subject of the over-aggressive arrest is charged with a Class 6 felony that has a 6-month mandatory minimum. And they should have had a speeding ticket, but it turned into something where they're facing 6 months in jail, a felony, and their life turned upside down, and ended up working out a deal and just letting it all go because they can't possibly roll the dice on something like that because it's so life-changing. The punishments reflected in this statute, the way it's enacted today, as it was passed in the heyday of the tough-on-crime movement back in the mid-1990s, has created a system where the punishments are completely way out of whack compared with the conduct that's at issue. And I can't say it much more eloquently than the senior senator from Richmond. The mental health situations described from the senator from Herndon. But I also just want to say a couple other things about mandatory minimums. Mandatory minimums do not work. We heard testimony in one of our joint courts, or joint judiciary rehab meeting, I think in July, where a professor from George Mason, who was on a national criminal reform task force, Dr. Robinson, where she testified that mandatory minimums have been studied, and they found that they don't deter anybody. They don't work. They don't solve anything. And I tell you what, the only people that mandatory minimums help are people who are employed in prisons and lawyers. Because people will pay people like me a lot more money to defend themselves on a mandatory minimum when they're facing the certainty of a lot of time in jail than if they're not. And we're going to have a mandatory minimum discussion next session as well. But this statute is a textbook example of why mandatory minimums don't work. And the concept, the idea that somebody, when they get involved in some kind of a situation with a police officer, they sit there and they're thinking, well, gee, it's Class 6 felony versus 6 months in jail, I'll take the felony, but not the 6 months. That's crazy. That's not how these situations arise. People don't sit there and contemplate or calculate what's going on. These situations are spur of the moment. They happen really fast. The onion ring flies out of the tray as somebody's being tackled. The water flies off the tray as the tray's being shoved back through the food slot, right? The spit leaves somebody's mouth after they got pepper sprayed in the face and they start spitting out because they can't see anything, and the spit lands on somebody's shoe. They're not sitting there thinking, geez, their whole future life isn't in front of them thinking about, those situations. That's not This isn't malicious wounding. Malicious wounding is where somebody does something with the intent to injure somebody. You do that, you get a felony charge, and you get a 2-month mandatory minimum. That we're not talking about. We're talking about situations which are much more minor. 70% of these cases have no injuries. And so that's what this case is about. And the last thing I'll say is if we want to do anything to help morale, if we want to help police, we want to help retention, the best thing we could do is pay them more money. Right? We had that debate last week because there was legislation that would restrict police officers' ability to organize so they can go get more money and improve their job conditions. Now, it's a fair point to talk about whether or not those unions ought to be involved in discipline. There's no question. That's a fair point. But what I've been hearing, 24 years I've been practicing, the police officers are most unhappy about is how much they get paid. And in Fairfax County, where you start off at $54,000 a year, where the average rent costs you $22,000 a year, you can't afford to live in the jurisdiction you have to police. And that's the case in many of our jurisdictions. And that is the one thing we can do to best improve morale in our police department. And that's something we should be seriously talking about after we pass the Senator from Hampton's bill next week, which is going to help to root out a lot of the bad apples, which probably are the ones that result in a lot of these charges that we're debating in this legislation. So I'd hope we'd pass the bill.
Mr. President. For purpose, Senator from Franklin County, Senator Stanley Rise.
Thank you, Mr. President. Would the senator yield for a question, the patron?
Will Senator yield?
I'll yield to talk about his union bill.
Senator yields. You have the floor.
Thank you, Mr. President. Rather than talk about the union bill, I think he brings up a point which I think we on this side of the aisle totally agree with, which is the low rate of pay for police officers throughout the Commonwealth of Virginia who protect us. And would the gentleman not agree with me that when it comes to our sheriff's departments, which are for the vast geography, the vast land and territory of the Commonwealth of Virginia, are the main source of law enforcement and protecting the people throughout the Commonwealth of Virginia?
Senator has the floor.
Mr. President, I don't know the exact proportion, but I know that I would say it's 50-50 if you count total police versus sheriffs is my guess, but it's more the land area. I agree with him on that.
Follow-up question, Mr. President. What do you
Senator yield?
Yeah, I'll yield.
And
yield. You have the floor.
And would my friend also agree that the people that determine the rate of pay for our sheriff's departments who do investigation, road work, take care of the jails, serve process, and even guard our courts, that the rate of pay for our sheriffs, our great sheriffs, is determined by this body and the one across the hall or now across the street in the House of Delegates?
Senator has the floor.
I would say to the senator that that's mostly correct, although I know in a lot of the localities I represent, the sheriff's pay is supplemented by the localities where they pay them extra so they can afford to live in the jurisdictions where they serve.
Final question, Mr.
Senator
President.
yields.
Mr. President, I'd ask the gentleman, would he not agree with me in the last General Assembly session, the regular session, that when I proposed a budget amendment to increase the salary of those sheriffs in the Commonwealth of Virginia, that it was voted down along party lines? And
Senator has the floor.
That meaning, Mr. President, that the Democrats in this body voted to kill my amendment, which would have raised the salaries of sheriffs.
Senator has the floor.
Mr. President, what I would tell the gentleman or remind him of is the fact that I'm pretty sure that his amendment would have caused the budget to be out of balance and therefore unconstitutional. And so, therefore, those of us who took our constitutional responsibilities to balance the budget seriously and voted against the measure because of that. And in prior bodies I've served in, that kind of amendment would have even been out of order, but I guess we don't do that here.
Mr. President, I now have one more question.
Will Senator yield?
I'll yield.
Senator yield. You have the floor.
Thank you, Mr. President. Finally, would he not admit that perhaps that's incorrect, that it was a budget bill that would have allowed skills games to fund increases in the Sheriff's Department? It has nothing to do with being out of order or would have unbalanced the budget.
Senator has the floor.
I would say, gentlemen, I don't recall it that way, but I'd have to go back and look at the tape, I guess.
Thank you, Mr. President.
Thank you, Senator. Do any other senators wish to be heard regarding Senate Bill 5032? Seeing none, the question is, shall Senate Bill 5032 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk will close the roll.
Ayes 21, noes 15.
Ayes 21, noes 15. Senate Bill 5032 passes.
Uncontested calendar, Senate bills on second reading.
Senior Senator from Fairfax, Senator Saslaw.
Mr. President, I move that all Senate bills on the second reading on the uncontested calendars on pages 2 through 5, that's SB 5047 through SB 5101, be advanced to their engrossment and third reading in a block after the adoption of any amendments thereto. Any senator desiring to remove a bill from the block, please do so after the clerk has read the number of the bill.
Senate will briefly be at ease.
Mitigating circumstances. Just so I get your full.
Senate will come to order. Senators will please take their seats. To explain where we are, we had a technical problem on the last vote, and so we'll need to recast the votes with regard to Senate Bill 5032. So the votes weren't recorded, so we'll do the voting over again. And we also need to do the debate over again. So for what purpose does, you want to start again? All right. No, okay. Without objection, we won't do that. Question is, shall Senate Bill 5032 pass? All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senator desire to change their vote? The clerk will close the roll.
Ayes 21, noes 15.
Ayes 21, noes 15. Senate Bill 5032 passes.
Uncontested calendar, Senate bills on second reading.
Previously, having made the motion, the question is, shall all Senate bills on second reading on the uncontested calendar on pages 2 through 5, Senate Bill 5047 through Senate Bill 5101, be engrossed in advance to their third reading in the block after the adoption of any amendments thereto, with the understanding that any senator desiring a bill be removed from the block will do so after the clerk has read the number of the bill. All in favor of the motion will say aye. Those opposed, no. The ayes have it. The motion is agreed to. The clerk will read the number of the bills.
Senate Bill 5047, reported from the Committee on Rules.
Mr. President.
Senator from James City County, Senator Norman.
Mr. President, I respectfully request that Senate Bill 5047 be removed from the block and passed by for the day, sir.
Without objection, Senate Bill 5047 will be removed from the block and will go by for the day.
Senate Bill 5068, reported from the Committee on Education and Health. Senate Bill 5080, reported from the Committee on Education and Health with a substitute.
Senator from Southern Fairfax, Senator Barker.
Mr. Chair, I move adoption of the substitute.
Thank the Senator. The question is, shall the substitute be adopted? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The substitute is adopted.
Senate Bill 5081, reported from the Committee on Education and Health with a substitute, and there is a floor amendment.
Senator from Southern Fairfax, Senator Barker.
Mr. President, my first motion will be to adopt the substitute.
Question is, shall
Mr. President, parliamentary.
Senator from Hanover, Senator McDougal.
Thank you, Mr. President. Parliamentary inquiry.
Senator's floor.
Mr. President, is the reason for the vote once the substitute is attached to the bill going to be 4/5 because it creates a date certain which requires that elevated vote under Article 4, Section 13 of the Constitution?
Senator, to your question, the amendment itself or the substitute itself would just need a majority vote or a voice vote. However, on final passage, which is not today, it would require a 4/5 vote at that time for passage.
Thank you, Mr. President.
Thank the Senator.
Yes, Mr. President.
Senator from Southern Fairfax, Senator Barker.
I now move that we take this out of the block and we'll deal with it, the fourth amendment later. No. We did.
Without objection, Senate Bill 5081 will be removed from the block.
Senate Bill 5083, reported from the Committee on Education and Health. Senate Bill 5088, reported from the Committee on General Laws and Technology with a substitute.
Senator from Alexandria, Senator Evan.
I move the committee substitute.
Question is, shall the committee substitute be adopted? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The committee substitute is adopted.
Senate Bill 5090, reported from the Committee on Education and Health with amendments, and there is a floor substitute.
Senator from Henrico, Senator Donovan.
Thank you, Mr. President. With the recommendation that we reject the committee amendments, I move the amendments.
Thank the Senator. With the recommendation that they be rejected, the question is, shall the committee amendments be adopted? All in favor of the motion will say aye. Those opposed, no.
No.
The noes have it. The committee amendments are not adopted. The Senator from Henrico, Senator Donovan.
Thank you, Mr. President. I now move that we consider the floor amendment.
Senator, want to waive the reading?
Waive the reading. Thank you, Mr. President.
Thank the Senator. The question is, shall the reading of the floor substitute be waived? All in favor of the motion will say aye. Those opposed, no. The ayes have it. The reading of the floor substitute is waived. Senator from Henrico, Senator Donovan.
Thank you, Mr. President. I now move the floor substitute and speak to that.
Senator has the floor.
Mr. President, this data bill came out of Education and Health, and it basically is an attempt to make communication to the public about the COVID healthcare crises a little bit more clear. Data has been spewed everywhere. It's very hard to interpret, and it's caused a lot of uncertainty and concern. And this bill, the part that does not change, we'll talk about tomorrow, the part that does change in the amendment is basically in alignment with a set of benchmarks that Virginia Department of Health has been developing but has not yet been made public, that looks at patterns and trends in communities and also looks at a composite index. And with that kind of reference point, communities will be able to know when they're ready to move forward and open up further, and it'll be a tool by which the data can be appropriately analyzed and applied to hopefully improve communication and decrease concern, and that's what the substitute does, Mr. President. I move the substitute.
Thank the Senator. Question is, shall the floor substitute be adopted? All in favor of the motion will say aye. Aye. Those opposed, no. The ayes have it. The floor substitute is adopted.
Senate Bill 5095, reported from the Committee on Education and Health with a substitute, and there is a floor substitute.
Senator from Henrico, Senator Donovan.
Thank you, Mr. President. If I may, can we please remove 5095 from the block and let it go by for the day?
Without objection, Senate Bill 5095 will be removed from the block and will go by for the day.
Senate Bill 5100, reported from the Committee on Education and Health.
Question is, shall the Senate bills be engrossed in advance to their third reading? That is all bills except for Senate Bills 5047, 5081, and 5095. All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The bills are engrossed in advance to their third reading.
Regular calendar, Senate bills on second reading. Sorry, 5081.
Senator from Southern Fairfax, Senator Barker.
Yes, Mr. President, this is on Senate Bill 5081, which was pulled out of the block. Have a floor substitute to adopt the emergency clause to this bill. This bill deals with public reporting on a website through the Department of Health, the outbreaks are occurring at different types of facilities and operations within the Commonwealth. So the motion is to adopt the floor amendment. We already did that. Yeah.
Right. Okay, so what we'll do, Senator, is first we need to adopt the committee substitute as the first motion, and then secondly, you have a floor amendment to the committee substitute, so we can address that second, but we need to waive the reading. So let's start with the committee substitute and adoption of that.
All right.
It's Senator Dunbar.
We already did that once, but I'll do it again. So I move the floor.
I think we stopped it in the middle.
You go, George.
Let's just do it again to clean it up.
All right. I will once again then move the committee substitute be adopted.
Question is, shall the committee substitute be adopted? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The committee substitute is adopted. Senator from Southern Fairfax, Senator Barker.
I now move then that we adopt the floor the floor amendment to the substitute.
Does the senator want to waive the reading first?
All right. I move that we waive the reading of the floor amendment.
Thank the senator. The question is, shall the reading of the floor amendment be waived? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The reading of the floor amendment is waived. Senator from Southern Fairfax, Senator Barker.
Mr. President, what this does is establishes, adds the emergency clause to the bill. This deals with outbreaks of diseases, et cetera, that occur in Virginia. As many people remember, actually there were several bills along this line that were proposed, and that's why we have a number of co-patrons, chief co-patrons for the bill here. During the pandemic that we are in now, for a period of time, the Department of Health and the Governor's Office were interpreting the Code of Virginia as not allowing them to provide reports of the outbreaks and of the different types of facilities and operations in the Commonwealth. What this would do was set up a website that would have that information that would be publicly available, that would deal with the facilities and operations where these situations were occurring, where these outbreaks were occurring, and it would provide the number of individuals who were infected by a virus in this particular situation and the deaths that occurred there. So what this would do is make sure that we can
5 will go by for the day.
Senate Bill 5042, a bill relating to State Board of Health public health emergency, patient visitation, notice to family emergency.
Mr. President.
Reported from the Committee on Education and Health, and there are 2 floor amendments.
Junior Senator from Virginia Beach, Senator Kiggins.
Mr. President, I'd like to request that bill go by for the day.
Without objection, Senate Bill 5042 will go by for the day.
Senate Bill 5045, a bill relating to criminal cases, fiscal impact statements, reported from the Committee on Rules with an amendment.
Senator from Eastern Fairfax, Senator Serville.
Thank you, Mr. President. I move the committee amendment.
Thank the Senator. The question is, shall the committee amendment be adopted? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The committee amendment is adopted. Senator from Eastern Fairfax, Senator Serville.
Thank you, Mr. President. I move the bill be engrossed and advanced to its third reading.
Thank the Senator. The question is, shall the bill be engrossed and advanced to its third reading? All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The bill is engrossed and advanced to its third reading.
Uncontested calendar Senate bills on first reading.
Senior Senator from Fairfax, Senator Saslaw.
Mr. President, I move that all Senate bills on first reading, on the uncontested and regular calendar, pages 8 through 10, at Senate Bill 5041 through 5120, that the rules be suspended and the first constitutional reading of the titles be dispensed with.
Thank the Senator. The question is, shall the rules be suspended? The first reading of the titles of Senate bills on the uncontested and regular calendars, pages 8 through 10, Senate Bill 5041 through Senate Bill 5120, be dispensed with. All in favor of the motion will record their vote aye. Those opposed, no. Are the senators ready to vote? Have all the senators voted? Do any senators desire to change their vote? Clerk, close the roll.
Ayes 34, noes 0.
Ayes 34, no 0. The reading of the titles is dispensed with. Senior Senator from Fairfax, Senator Saslaw.
Mr. President, I now move that those said bills be passed by for the day.
Thank the Senator. The question is, shall the Senate bills on the uncontested and regular calendars now on second reading go by for the day? All in favor of the motion will say aye. Aye. Those opposed, no. The ayes have it. The bills will go by for the day.
Memorial resolutions.
Senior Senator from Fairfax, Senator Saslaw.
Mr. President, I move that the three memorial resolutions on page 11, that's SR 522 through 25, be considered in the block in the usual manner, waiving the reading of the resolutions thereof with the understanding any senator desire to remove a resolution from the block, please do so after the clerk has read the title of the resolution.
Thank the Senator. The question is, shall the memorial resolutions on page 11, SR 522 through SR 525, be considered in the block in the usual manner, waiving the reading of the resolutions thereof, with the understanding that any senator desiring a resolution be removed from the block will do so after the clerk has read the title of the resolution. All in favor of the motion will say aye. Aye. Those opposed, no. The ayes have it. The motion is agreed to. The resolutions are before us in the block. The clerk will read the titles of the memorial resolutions.
Senate Resolution 522, celebrating the life of Richard Dwayne West, MD, FACS. Senate Resolution 523, celebrating the life of Michael George Munigian. Senate Resolution 525, celebrating the life of Injun Mahmet Artamel.
The resolutions will be agreed to in the usual manner. All those in favor of agreeing to the memorial resolutions will please rise. The resolutions are agreed to.
Commending resolutions.
Mr. President, can we take
Senate
Senate
Resolution
Committee Resolution
521,
521
commending our
by
Agricola.
for the day?
Senate Resolution 524, commending human food RVA.
Senior Senator from Virginia Beach, Senator DeStaff.
Mr. President, can we take Senate Resolution 521 by for the day? I'd like to get some other individuals from Hampton Roads to sign on.
Without objection, Senate Resolution 521 will go by for the day. Senior Senator from Virginia Beach, Senator DeStaff.
Thank you, Mr. President.
The senator wants to speak to Senate Resolution 524.
Yes, Mr. President, I'd like for it to pass. Thank you.
Okay. Thank the senator. Question is, shall Senate Resolution 524 be agreed to? All in favor of the motion will say aye. Those opposed, no. The ayes have it. Senate Resolution 524 is agreed to. Senator from James City County, Senator Norman.
Thank you, Mr. President. I would ask respectfully that when we adjourn today, that we adjourn in the name and honor of a former Lieutenant Governor, John H. Hager, who passed away on August the 23rd, sir.
Thank the senator. Senior Senator from Fairfax, Senator Saslaw.
Mr. President, members of the Senate, in an attempt to get us out of here before November, any bills that were introduced, any bills that have been introduced after noon today, any bills that were introduced after noon today, committees will not be meeting on. I think that, a week has been long enough, and this was never intended to be a regular general session. So what's in the committees now is all that's going to be heard. And I appreciate your cooperation with that. And I know so does Senator Norman.
Thank the senator. For what purpose, the senator from Fairfax City, Senator Peterson, rise?
Thank you, Mr. President. Rise for a very brief announcement.
Senator's the floor.
Could I have, upon adjournment, a very informal and ad hoc meeting of the Senate Ag and Natural Resources Committee?
Thank the senator. Do any other senators wish to be recognized? Seeing none, the clerk will announce any announcements on the desk.
Today, August the 26th, 2020, the Committee on Agriculture, Conservation, and Natural Resources will have an ad hoc meeting at the chairman's desk immediately upon adjournment. The Committee on the Judiciary will resume 15 minutes after adjournment. This is a virtual meeting. The Committee on Commerce and Labor will meet immediately upon adjournment of the Committee on the Judiciary. This is also a virtual meeting.
Thank you, Madam Clerk. Is there any other business to come before the Senate? Seeing none, call on the senator from Portsmouth, Senator Lucas.
Thank you, Mr. President. Mr. President, I move that the Senate do now adjourn until 10 a.m. on tomorrow, and in so doing that we adjourn in memory of former Lieutenant Governor John H. Hager. Thank you.
Thank you. Question is, shall the Senate adjourn until 10 a.m. tomorrow, and that when we do so in the name and honor of the late Lieutenant Governor John H. Hager. All in favor of the motion will say aye.
Aye.
Those opposed, no. The ayes have it. The Senate stands adjourned until 10 a.m. tomorrow in the name and honor of Lieutenant Governor John H. Hager.